Hi, I'm Jeff Hoyt, editor-in-chief of SeniorLiving.Org. For many low-income seniors, their home is the only asset they can leave to their family. But if they're in debt, how can they give the home to their kids without their debt having to be paid off first? Attorney Eric Olsen will explain how seniors can leave homes or other assets to their survivors without putting in their estate, which first must be used to pay off debts. Eric is the founder of the Helps nonprofit law firm, which educates seniors on how to maintain their financial independence. He'll lay out why wills and trusts don't work, the advantages and disadvantages of his method, why it works even if you have a mortgage, and how his law firm can help you at little or no cost. Due to social distancing guidelines, we'll be conducting the interview online, via Zoom. Hi, it's Jeff Hoyt, editor-in-chief of SeniorLiving.Org. And today I'm speaking with Eric Olsen. Eric's an attorney and the executive director of the Helps nonprofit law firm, which helps seniors and others who are struggling with debt. Welcome, Eric.
Glad to be here with you, Jeff.
Thanks for taking the time.
You bet.
So today I want to talk about seniors who own a home, maybe a modest home, but it's really their only asset. They don't have stock portfolios or other investments. And towards the end of their lives, they may not be able to pay for medical care, things like that, whatnot. They're running up debts. And the home is something they want to pass on to their children. And I'm wondering, is there a better way than just leaving the home in a will to the kids so that they can, we want to make sure it gets to the children? What can they do to protect the home?
I deal with this question every single day. And I guess I want to talk about a will, how it works. Okay. You get on the internet, and I've read umpteen websites or articles that say, you have to have a will, you have to have a will, you have to have a will. Okay. Well, for a lot of seniors, a will is a guarantee to disinherit your kids. Okay. It's a way that they won't get anything. And I'll explain that. Or I'll talk to a senior and they'll say, well, I got a trust. Their kids are going to get the trust. They're going to get my home. Well, that's a revocable trust. And that's another way, just like a will, to maybe disinherit your kids so they don't get anything. And the reason why is both a will and a trust provide that when you pass away, before your heirs, before the person's, your children, whoever you want to get your property, get the property, the debts have to be paid. So if you're a senior and you're lower income or medium income or whatever, and your major asset is your home, but you have a lot of debt for whatever reason, credit card debt, medical debt, maybe you end up in a nursing home, whatever, when you pass away and you have a will or a trust, your debts have to be paid before your kids get anything. Yeah, and there is a better way to leave property for kids.
Oh, well, let's hear about the better way then.
Okay. Before we talk about this, Jeff, there should be some caveats or disclaimers that we need to discuss. We're generally talking about seniors with lower incomes, not big estates. Maybe they have a home with not a huge equity, that kind of situation. It goes by state law. Not every state has this option, but almost all of them do. And you may have to do a little research or whatever. There is a deed, or almost every state has a way that you can add someone's name onto the home as a joint owner with survivorship rights. So we're used to husbands and wives owning property together as survivorship rights, so that when the husband passes away, the wife gets it, or vice versa. Sometimes that's called tenants by the entirety. That's a legal term. But so, and most couples own the property jointly with rights of survivorship. Okay. Which is fine. But if you're elderly and you've got a little equity in your home and you want your kids to get it, you could consider adding your kids onto the deed with you and your wife, or with you if you're a single parent, as a joint tenant with survivorship rights, which means that, let's say for a husband and wife owned a home and they had 2 kids. The husband and wife could deed the home to themselves and the 2, let's say 2 daughters, as joint tenants with rights of survivorship. Okay. So that means if the husband passed away, the home would go to the wife and the two daughters. And then when the wife passed away, then the two daughters would get the home as joint tenants with rights to survivorship. Now, what's nifty about that is there's no probate. It just automatically goes to the joint tenants, which means that any debt that is owed by the parent does not have to be paid. Okay. Now, let's say, for example, one of the parents got sued for a credit card debt or something, and there was a judgment. Okay. If that lawsuit took place after the child's name was on the property as a joint tenant, okay, when the parent dies, that lawsuit disappears, that judgment disappears. A judgment is not a lien on a particular piece of property. A judgment is a lien on a person and the property that person owns. Okay, normally in the county where they live or locality. Okay, so when you die, the judgment disappears. Therefore, the property automatically transfers to the joint heirs, the joint tenants on the property, automatically by operation of law. Therefore, that judgment disappears. It's no longer attached to the property because you no longer own it. You're dead. So it's really kind of a nifty way to protect property for family. Now, we're not talking about just deeding it to your kids. We're talking about having them own it jointly with you with survivorship rights. There's some caveats about that, and we can talk about those, but that's what we're talking about here.
So what are the caveats? What are the downsides?
Well, okay. So I'll tell people about this, and I'll say, well, okay, if you do this, you understand that, if you decide to sell the property down the road, your kids have an ownership. They're going to have to sign off on it, and they'll always tell me, oh, there won't be any problem with that. Okay, I guess if you were nervous about that, then you wouldn't want to do this. Okay. So some LLA attorneys who provide estate planning advice, Jeff, they might suggest a different approach. They might discuss potential problems with adding children as joint owners. Maybe these children might have financial problems down the road, or they might be concerned about some tax issues or other problems. However, many lower income seniors really can't afford the cost of an estate planning attorney. In my opinion, the potential for these problems would be very minimal. So that's one of the caveats. I guess another caveat could be if you're lower income and we're aware of what we have Medicare, but if we have medical expenses we can't afford, or we have to go in a nursing home, then we could qualify to get what's called Medicaid. Okay. Now Medicaid, there's a look back period if you try to transfer or give property away within 5 years. It's Medicaid's a federal program, but it's governed by the states. And so there are certain rules about giving property away could cause a problem. And definitely a problem if you just deeded property to your kids, just gave it to them, or money or whatever, gave it to them. Okay, that could be an issue. But with adding someone's name as a joint tenancy, that's not quite the same. You're adding someone for inheritance purposes. There could be a problem, I guess, in certain states, but we don't see that crop up very often. And then you'd have to deal with it if it did, but we don't see it as an issue. If you didn't do this, then it's pretty much guaranteed Medicaid would get your home or with the asset to reimburse them at your death. But if your kids were joint tenants, depending on how long they've been on there, et cetera, and what you've done to help, it's less likely there would be a problem of the state needing to be reimbursed for expenses. There won't be a problem with your creditors.
If I am sued by a credit card company and then I make my kids joint tenants, that wouldn't work. But if they're already joint tenants and then when I get sued, then it would be okay. Once I die, the debt dies with me.
That's right. I mean, a person theoretically add a child on as a joint tenant, even after they've been sued, before a judgment was taken against them. Okay. Now, you could probably think of, little problem areas that could crop up, like, hey, is that, if you add someone as a joint tenant, is that a fraudulent transaction or things like that? You could make an argument maybe that it is, or it's questionable. I've never seen it happen in 40 years. Okay, I mean, what's the worst thing you got? You could undo it, but it's unlikely that would ever crop as being an issue. But you're right. Yeah, if you have your kids on, the title is joint owners, and then you pass away, judgment disappears. Now, if you want to sell the home before you die, then yeah, the judgment may be a lien that may have to be dealt with. But then in a lot of states, judgment, there's a sunset law for judgments to go away. Maybe after 10 years, it goes away. Sometimes they can be renewed. Some states have a very limited time when a judgment can be collected on.
But for the most part, when there's no judgment against somebody, doing this is not fraudulent or anything like that. It's just a way to pass on the asset to the children.
Well, I don't think it's fraudulent even if you have debt. I mean, you're doing it for inheritance purposes. The kids may be on there, but you can own property jointly with someone. It doesn't necessarily mean that they're entitled to an equal share in the property. You're doing it for inheritance purposes.
If the home still has 2 years of mortgage payments left on it, is it a problem? Do I have to get the mortgage lender to sign off on it?
No. The mortgage might say that if you're going to do a deed or transfer something, you're supposed to do that. Okay. But they'll never enforce that. It won't be a problem. You don't have to have the mortgage permission. I mean, a person can do it themselves. I mean, we have an email from Helps that we give our clients that gives them the links to where they can get the legal form filled out themselves. The legal description has to be signed by whoever is giving the property to whomever, like the husband and wife would sign it and it'd be notarized. And then it's taken to the county recorder's office, the county clerk, and recorded. And there's a little recording fee, $50, $75, whatever it is. Boom, it's a record.
And what if the children run into financial issues? In other words, can they borrow money against the house, or they run up so much debt that someone goes after the house to pay their debt back?
There'd be no way they could literally borrow on the house. I mean, it'd be, I can't see that. I mean, with title issues and problems like that, no legitimate lender would loan money to someone who's a joint tenant on something like that.
I was just asking if the kids are having financial problems.
Oh, if they had financial problems, I mean, you can always talk about UFOs, right? Do they exist? We can always talk about getting struck by lightning. You can always talk about maybe a meteorite hitting us. I could think of a theory where if a kid had financial problems and had to file bankruptcy, that maybe, and they say, hey, I'm a joint owner in this property, that could create a little bit of problem. I don't see how a senior would ever lose the property, because their position is, hey, the kid's only on there for inheritance purposes. They don't really have any ownership interest in it. I mean, yeah, I guess you could think of areas where there could be a problem, but most of the time, that wouldn't be an issue. I mean, you can get really fanatic about worrying about what ifs. So we're talking a lot about generalities. People can consult with a local attorney if they want about this kind of thing. But they should remember that a lot of things in life we deal with odds, and the odds of something like that being a problem are really remote. I can't remember it ever happening in my entire practice.
So what about on a smaller scale? If somebody had a car that was worth $20,000, is the same thing that they could pass on their kids if they put them on the pink slip?
You bet, they can do it. They just need how to add someone's name onto a car title. Now, it could be a little bit difficult if there's a loan on the car when they don't have the pink slip. Okay. And then it's governed under state law about how to do that. I mean, they could execute a bill of sale to their kid and for $1 or whatever, and just have the kid hold it. But yeah, they can, or, by the same token, you could add your kid's name as a joint owner on your bank account. I mean, there's ways they could do things so that they really don't need a will. Okay. Because And as far as personal property, furniture and stuff like that, you don't need to probate that stuff. I mean, we're talking about seniors on the lower end scale of income, there's just no value there. And you got to realize before creditors get anything, the cost of your burial has to be taken into account, and your cost of your death and that thing. So yeah, a car could be added into the title. Your name could be added to someone's bank account.
So if someone has legal questions concerning debt, they're swimming in debt, they're struggling in debt, they have questions about passing on their home to their children, or they have no home and they really have debt issues, how can they reach out to you and the Helps law firm?
Helps is a 501c charity, and our main function is to represent seniors who have debt they can't afford to pay in order to stop debt collector harassment under what's called the Federal Fair Debt Collection Practices Act. If a person is represented by an attorney, debt collectors have to leave them alone. And so, we educate our clients, their income, Social Security is protected, their pension's protected, their other assets are safe. And then our second mission to educate them how to maintain their financial independence. So that's kind of this part of it is, we kind of educate them as an aside about how to help their children out to leave their little bit of asset to their kids. Because if you're poor or lower income, it's really important to you to leave whatever you have to your your kids. And so, we'll tell them, we'll educate them, and then they can do that on their own if they choose to do that. That's not our main function, but it's a kind of a side issue that we do with our clients. And, but seniors need to know about that. I kind of think that, wills and trust, they may protect you from probate issues, maybe, especially a trust will, but it won't do anything about your debt. And that's where the problem will come in. And that's why having your kids as joint owners with your property solves that.
And if someone wants to reach out to Helps, how do they do that?
We're all over the internet. Helpsishere.org is our website. Helps nonprofit law firm. Help with an S on the end of it. Our phone number is 855, toll free, 855 HELPS, HELPS US, HELPS US, or 855-435-7787. We help seniors all 50 states. We're the only law firm in the nation that does what we do, nonprofit law firm.
Well, we appreciate what you do. Thank you so much, Eric, for taking the time, and we'll be talking to you again soon.
Thanks for having me, Jeff. Really appreciate it.